Good afternoon. Call this meeting to order. Welcome to meeting number 73 of the House of Commons Standing Committee on Government Operations and Estimates. Pursuant to the order of reference adopted by the House on Wednesday, February 15, 2023, the committee is meeting for clause-by-clause consideration of Bill C-290, an act to amend the Public Servants Disclosure Protection Act. Colleagues, just a reminder, when you're speaking, to make sure you keep the microphone away from your earpiece away from the mic, so avoid feedback with our valued translators. Colleagues, last meeting I mentioned we'd address the issue of the nominee for the Public Service Integrity Commissioner. If we have consent, I'm going to propose that we will meet with the nominee on Wednesday for a 5-minute opening statement and then 1 6-minute round with each department. Are we good with that, colleagues?
Agreed, thank you.
So be it. I'll get to you, Ms. Kusi. Are those bells?
Do it really.
Oh.
Are you serious?
I would like to jump on that.
Okay.
Sorry, we agreed on the feature, right?
We agreed for Wednesday.
Yes.
And this,
And we have Bill's 30-minute vote. Colleagues, can we have UC to continue?
Yes.
Bill, 5 minutes before
yeah.
the bell? Great. Ms. Kusi, you had something, please?
Yeah, no, thank you very much, Mr. Chair. And I really hope that we can come to a fast resolution on what I'm about to discuss here today, as I think that it is a matter that has been before this committee several times before, and that is on what I believe is a potential breach of privilege. So, Chair, I would ask you listen to what I'm about to go over in an attempt to sort of demonstrate how I feel this has been breached here for not only myself, but all of the members within this committee. And as I said, I do hope that we will have the support of the NDP and the Bloc as well as the government in this recognition so we can move swiftly on to 290 and get that bill, which I know the Bloc is very anxious to do so, back to the House for the next step. But the breach of privilege, Mr. Chair, is as a result of several things, I will say. The first is our repeated attempts in an effort to get documents from the different departments, and we have, as of today, still, I believe, 6 of 21 organizations who've been asked 3 times. The first on January 18th, the second on March 5th by yourself, Mr. Chair. My goodness, March 5th, what month are we in now? We're in June here, so this is like 3 months ago. And then shortly after, again, after discussing in this committee on March 8th. So for a third time. And yet they haven't completed their submissions, and 16, in fact, submitted redacted documents when, in fact, McKinsey themselves had provided those unredacted pages. So, that is certainly the first reason, is that we've asked for these documents on several occasions. We certainly wanted to hear from all of the departments. We've heard from some of the departments, but I have some further information here which tells me it probably isn't even necessary for us to hear from the remaining departments that exist. And it seems as though there seems to be some type of lack of will from the committee to move forward on this. And I recognize we want to get 290, we want to get it past the House. The Conservatives are committed to doing that. I hope everyone else is as well, understanding the important testimony that we did hear. But that would be the first one, is we've asked 3 times for these documents. We have not received these documents. Le deuxième, bien sûr, ça c'est à propos des droits des...
The second, of course, is on the right to access to official languages. It's very important to see that we have not had access to documents in both official languages. And there were redacted documents. We need to have all documents in both official languages, of course. Julie has been a good spokesperson, showing why we need these official language documents. And we also have from other parties Mr. Godin, who is here to show why we, the Conservatives, think it is important to have all documents entirely translated in both official languages. So that was the second reason.
You know, very important that we receive everyone from the departments to explain to us why we did not receive the documents. But I believe I have, in fact, here a communication that moots that, Mr. Chair, and it is a communication from the Privy Council office from Maya Welburn to Mr. Paul McKinnon, CC'd Aaron Mather, Linda Nagayan, and Jean Citra, where Mr. McKinnon had asked Ms. Welburn if he thought that he writes, "Good morning, remind me," and this is on June 6th, so around the time that we had the first group, "if passed, it's not binding on government to produce documents." Set from my iPhone, as we all do in this day and age, Mr. Chair. Now, the next part I'm going to read out is that it's very shocking. It's actually in contrary to what the legalist specialist said, who was in there visiting, but in fact reads, "The government considers it non-binding if Parliament does." So Parliament, according to this communication, this committee, according to the PCO, does not have to listen to the will of this committee or the will of Parliament. They just have to listen to the government, Mr. Chair. If that is not a breach, I cannot think what type of breach of privilege might exist. If the PCO, the acting body of this government, is saying that what we decide here, what all parties on this side of the House, I should say, in the opposition decide, in fact, we as a committee decide, is not movable, is not actionable enough to produce documents. And I'll finish the communication, Mr. Chair. The government considers it non-binding. That's just so insulting. It's difficult to read. Parliament does. If government doesn't produce documents as ordered by the House, then the matter can be escalated in a number of different ways, including as far as finding the government is in contempt, minister or official being called to the bar, non-confidence vote. This is the same kind of scenario as last June with Ian Stewart being called to the bar, and regrettably, we remember how the government hid behind this event. I think it was truly an event in the House of Commons, Mr. Chair. But this is where it gets even juicier, Mr. Chair, unfortunately. Main difference now, and I'm quoting again, main difference now being the supply and confidence agreement with the NDP. So this document goes on to say, beyond the insult, that us deciding as a parliamentary committee is not enough for this government to produce documents, that it is supported as a result of the supply agreement between the NDP and the Liberal government, Mr. Chair. So for these three reasons, the denial of the documents in redacted form, le fait que nous n'avons pas les reçus complètement.
The fact that we have not received them entirely in French.
English, that second reason. And then finally, this insulting communication, which I have in my hands, whereby this government actually believes that it is not their responsibility, and who knows who the PCO has been instructed by. We've tried to pull this information from them in the past regarding other matters, but they have been instructed that it is not. They are not required to follow the will of Parliament. They are not required to follow the will of this committee, Mr. Chair, and bring these documents to us. And if these, why need we even listen to these other departments if the PCO has been instructed that these documents need not be supplied to this committee? It's more than enough, I believe, to consider it a breach of privilege, and so. Perhaps then, Mr. Chair, I will read the motion that I brought forward here today, and you can certainly take the time to determine if you agree with my assessment as well. Yes, copies have been distributed to all members. Okay, or they are being distributed to all members. So I will now read this into the record if we're ready. And again, before I read it, Mr. Chair, I hope we can come to a fast resolution that this is in fact a breach of privilege, so that we can move forward to 290, which is of paramount importance, certainly for the block, and of interest for the Conservatives as well. And with that, pardon me?
Said if it was so important that you do this later.
I'm
Can you
reading it into the.
finish
I'm
your-
reading it now. Well, yeah, I'm reading it now. That further to the evidence received to the committee subsequent to the motion adopted on Monday, April 24th, 2023, in relation, and by the way, I should say that, if the member for the NDP feels so strongly about moving on to 290 as we do, then he'll vote in support of this motion and we can just move forward to 290. I think that would be the best way that he could show his support for 290 right now, Mr. Chair. But I'll continue reading. Actually, I'll start again. That further to the evidence received by the committee subsequent to the motion adopted on Monday, April 24th, 2023, in relation to the redactions and improper translation of documents ordered for production by the committee on Wednesday, January 18th, 2023, the committee is of the opinion that there is a potential breach of privilege which must be reported to the House, and therefore, notwithstanding the decision of the committee on Monday, April 17th, 2023, the committee adopt the report drafted by the analysts entitled Questions of Privilege on Providing Documents to the Committee as amended, instruct the chair to present this report to the House forthwith. And I'm going to pause here again, Mr. Chair, and say that we don't want to hold up any of the House business. We just simply want this referred to the House. We don't want to mess up the schedule anymore. We are all anxious to get home to our constituents and service them over the summer, but we feel this has to be dealt with prior to leaving that. We just want this referred to the House. That's all we want, Mr. Speaker, and I believe will satisfy the breach. Adopt the report drafted by the analysts entitled Question of Privilege and Providing Documents to the Committee as amended. Instruct the chair to present this report to the House forthwith, and that the committee request a comprehensive government response pursuant to Standing Order 109. And yes, so I hope that this committee will take, well, I'll wait for your ruling, but I would hope that should you potentially decide for it to be a breach, that this government would take it seriously, pass this motion, send this off to the House, and we can swiftly move on to 290. Thank you.
Right. Thanks, Ms. Kusi. The motion is in order.
Okay.
I don't have anything else to offer except it is in order, and you can continue if you wish.
Sure. Well, as I said, I feel as though there certainly has been a breach of privilege, and I'm really looking forward to this group passing this motion and referring this to the House so that we can receive all the documents that we should, as parliamentarians, be allowed to see. And so, I'm really looking forward to this passing and this being sent to the House.
Thank you. Mr. Housefather, then Mr. Jouari, then Mr. Kuzmirchuk, Mr. Johns.
Thank you so much, Mr. Chair. Obviously, the situation is frustrating for everyone, but I want to lay out how this would work, because what Ms. Kusi is saying is I don't believe the way it would accurately happen. If the committee were to adopt her motion, any member of the House could raise this as a question of privilege.
Sorry, can I interrupt for a sec?
Yes?
Would you lower your mic a tiny bit?
Oh,
You're not
sure.
as loud as you normally are.
Sorry about that. Is that better, sir?
Not as clear as you normally are. I'll restate.
Is that better, Mr. Chair?
Just a moment. We're just confirming with the interpreters, Mr. Housefather. Yeah. We're good. Thank you. Please go ahead, sir.
Thank you very much. If we were to refer this to the House, then any member of the House could raise a question of privilege, which would, if the Speaker rules that it is a prima facie case of privilege, end up, taking up all kinds of time in the House, and not to mention the representations that would be made to determine or argue that it was a question of privilege. So while I'm sympathetic to the arguments being raised by my colleague, I definitely do not want the valuable legislative time of the House this week being taken up by a question of privilege and stopping legislation from being adopted. So for that reason, Mr. Chair, I would not be prepared to support passing this today in any event. Thank you very much. And I'll turn to Mr. Kuzmierczak, who I think was next.
Thanks for bypassing me, Mr. Housefather. I'm not getting in
No,
my
not
word
what I
count,
meant, sir.
Mr.
Not what I
Kuzmierczak.
meant, Mr. Chair.
Actually, I think, Mr. Chair, I think it was Majid who was on deck second. Am I not correct? That's at least how it came across.
Yeah, that's right. He was. I'm sorry. I thought he was waving away, but go ahead, Majid.
You always have to refer to defer, I should say, to your senior.
Oh, okay. In age, maybe not in wisdom, but having said that, okay. So there's a number of things. Our colleague, Madam Kuzi, referred to a number of emails, which I don't think at least our side is in a position of having had an opportunity to look at it and see, because that's the core of the conversation that we are having. I think the analysts have done a good job in a very chronological order for a certain period to reflect all the facts, and that was shared with us. So thank you to the analysts. But the gist of the discussion that Madam Kuzi is having is that she somehow has had an opportunity to have access to certain information, which has led her to believe that the government does not intend, under any circumstances, to provide the document that we've asked for. And yet we have another meeting on Wednesday, and I think this would be a great opportunity to see whether those who are referred in this emails could be present and answer the question of what this means. Without the access to those emails and verification, it would be very hard for me for today to make that decision to be able to support. So that's why I was asking, is it possible for us to get access to those emails and understand what the contents of those are, and make a decision then? Because if those are the cases, and then we could compile that and put it in a report and send it out, because that's really the core of the conversation, or what you're justifying. And I'll stop there, because I don't want to filibuster or kill the time. Thank you.
Yeah, Mr. Kuzmierczak, then Mr. Barrett. I apologize, Mr. Kuzmierczak, then Mr. Johnson, Mr. Barrett.
Well, thank you, Mr. Chair. I appreciate the opportunity to speak to this, and I just wanted to say that I think my colleague, Mr. Housefather, again, as is his standard, he has really gotten to the heart of the matter, which is, again, even though we take this matter seriously, the matter of privilege, and of course we want to get to the bottom of what are the reasons why the documentation would not be provided by the various agencies unredacted. The concern here is that this will open up an opportunity for our colleagues on the Conservative side to simply delay the work that's being done in the House of Commons, and that work is too important. That work is absolutely too important. And we see, for example, in other committees, questions of privilege being raised by the Conservatives, and tying up the work of those committees for numbers, multiple meetings. And for me, I was elected here to this committee, and I was elected to this House to get work done. And what I'm seeing in this committee, I'm seeing a tremendous drift in the work of this committee, a tremendous drift. I mean, we have drifted off course. We have 8 studies that have been opened up: McKinsey, the GG expenditure, outsourcing, diversity and procurement. Do you remember that one? ArriveCan, air defense procurement, national shipbuilding strategy, Bill C-290. I mean, these are all paramount. These are all important studies, all of them important studies. All of them we've opened. Not a single one we finished. And so, I look at this McKinsey study. I see the mountainous production of papers, hundreds of thousands of documents, millions of words submitted, millions of dollars. I think the PBO estimated $9 million in translation alone. I mean, if delay is the goal, if halting of the work of this committee is the goal, if delaying the work of Parliament is the goal, I have to say that it's disheartening. And again, we see these tactics time and time again. And so, again, I weigh those concerns. With again the seriousness with which we take this question of privilege, this issue that is before us. But again, let's call a spade here. We've seen this before. This is not new. There's nothing new under the sun. We've seen this before. We know how this plays out. There's too much at stake. There's too much work. And especially this last week, Canadians expect us this last week to buckle down, to work together, get legislation passed that they are looking for us to do to demonstrate leadership. For that reason, I can't support this. I support the principle of it, but I see where what door this would open up, and it would only delay the work of this committee, which again, we have been blown way off course already. It's time to rein this back in. I'm turning to my colleagues across the table in the NDP, in the Bloc, and in the Conservatives. Let's right this ship. Let's get it back on course. Let's get these committees' studies passed, and let's do the work that Canadians expect us to do, and especially this last week in Parliament. So for that reason, I don't think I can support this. Thank you.
Thank you, Mr. Kuzmierczak. Mr. Johns?
Yeah, thanks. So a couple things here. We heard from Matthew Shea from the Privy Council Office. He appeared at this committee. He's the Secretary to the Cabinet, Ministerial Services and Corporate Affairs, and the Chief Financial Officer. Now, he brought to the attention of this committee when we grilled him about the redactments. He cited the Open and Accountable Government document, and he cited in Accountable Government in 2011, the previous government issued the following guidance to ministers in the public service. And the same guidance was issued by the current government in Open and Accountable Government in 2015. And he quote, I'm going to read this. Public servants also have a duty to hold in confidence some of the information that comes into their possession in the course of their duties. There is a tension between that obligation and the request of parliamentarians for disclosure of that same information. When appearing before parliamentary committees, public servants should refrain from disclosing that kind of confidential information. For instance, because the information is confidential for reasons of national security or privacy, or because it consists of advice to ministers. Accounting officers should not disclose confidential information, including advice to ministers, even where that information pertains to matters of organizational management. Lastly, in practice, officials should endeavour to work with members of Parliament in cooperation with the ministers and their offices to find ways to respond to legitimate requests for information from members of Parliament within the limitations placed on them. End quote. Now, this was brought in, this policy, by the Harper Conservatives. We should be looking at this policy and having a conversation around that. If we've got more questions about these redactments, we should be bringing Matthew Shea back here in front of this committee, Mr. Chair. And I appreciate Mr. Kuzmierczak talking about adrift this committee. We haven't gotten a study done. In fact, the Conservatives keep bringing forward motions that could be included in the reports, whether it be on the Governor General, on McKinsey, and I'll say this, that we've got 9 studies going right now. This could be included in the study on McKinsey. We have 220,000 pages so far, and this is what this committee has received. Now, I just want to give an idea. It would take 30 seconds per page to look at. It would take 1,833 hours and 20 minutes to review these documents. It's 52 full-time weeks. Since it's only been a few months, it'd probably take about 4 full-time staff to go over the documents we've gotten so far. So far. And I don't believe anyone around this table has done that, unless you've somehow got a budget that I don't have in my office, or you got a pile of volunteers that want to go through 220,000 pages. So I suggest we include this in our final report. That would make sense to me. So we can get to C290, or we can get Matthew Shea back here and we can ask him more questions, because I have a lot more questions before I want to send this to the House, Mr. Chair. And I hate redactments, and I hate this policy. I think it needs to be reviewed. Clearly, it's a problem for this committee. But I don't believe that sending this nuclear approach to the House is the right approach. I think we should be doing some work here in this committee before we do that.
Mr. Barrett, real quick, and then we'll suspend for voting.
Yeah, thanks, Chair. So I would just say quickly that, this is looking for a comprehensive government response, one, so that concurrence is not moved on it in the House. Two, that we would be happy to see this moved on Wednesday, so that the House is going to rise before the Speaker would return, but then it is in possession of the House. So there's no intent to delay, and I can have that assurance made by the opposition House Leader to the government House Leader that there will be no question of privilege raised by any members of the official opposition. Three, Chair, the agreement was by government members and by the members of the NDP that if we gave time and that if we heard from these witnesses, that they would refer this to the House. And so then if someone wants to amend this so that it's reported as soon as Wednesday's meeting's over, then that would be consistent with everyone keeping the word. Anything less than that is a complete bait and switch.
Thanks. We are going to suspend till after the vote, colleagues. You're back in session. Mr. Barrett?
Thanks, Chair. In spite of conversations had the last time the subject was raised, there is obviously not going to be any agreement on this today. We have business in 290 to deal with. I move that we adjourn debate.
Should we vote on that, colleagues? Or on division? Or it looks like we have UC to adjourn debate. Thanks, we'll do on UC. Give us a couple seconds, colleagues. I'm going to excuse our analysts and bring in our legislative clerks. Mr. Housefather, you had your hand up. You put it down.
I did, Mr. Chair. I'm so sorry. I was wondering if I know we adjourned debate, but I was just wondering. I think the request had been made by Mr. Johari, if we would be able to get a copy of the email that Ms. Kuzi had read into the record when she had intervened previously. Thank you.
I'm sorry, of the motion or?
No, she read an email that was from the Privy Council office, dated June 6, 2023, that she used to argue for the motion. And since none of the rest of us had seen it.
I'll ask if she wishes, but I'm not sensing a desire to at this moment. No, sorry, the answer is no. We will get to C290. We're on clause 33. We're starting with NDP 15, which is page 35 of the package. Mr. Johns?
Yeah, thank you, Mr. Chair. So this requires the publication of routine. Currently, the information provided in annual reports provides little insight into operational performance and no basis for monitoring, evaluating, or improving the system. The statistics provided conceal serious anomalies such as cases remaining dormant or receiving little or no attention for several years. And averages do not reveal this. So such cases have thus far been uncovered only incidentally by other means, such as the release of PSIC's case management data following Christine Oumé's resignation in 2010 and investigations of 2 specific cases by the Auditor General. So under this amendment, the information provided in an annual reports would shed some light on operational performance and would provide some basis for monitoring, evaluating, and improving the system. Knowing the information duration of cases would reveal whether any cases are taking an unreasonable length of time to process. It's a no-brainer. This information is already captured in the Commissioner's case management system. So, Mr. Chair, just to save for time, could we just vote on this now?
Sorry, Mr. Fergus has his hands up. Mr. Fergus?
I really do appreciate where you're trying to go with this amendment. Unfortunately, I have two important concerns with it, which I think you would agree with me too. And it's not in the case of what you brought up, which I think was important, but it's a matter of confidentiality. Mr. Johns, as you know, people's health records, especially, in the case of some people who might have faced reprisal, they might have had some mental health issues caused by the reprisals. This is something which you don't want to have tracked, or, how can you secure the confidentiality of that information? And then there's a larger issue of these are just only regarding cases that PSIC, the Commissioner, has seen or has been brought to his attention. What about the cases which are... so I'm sort of offering an opposite side of this, but what about the cases which have been resolved internally without the PSIC's involvement? So I'm just, on one hand, I understand where you're trying to get at, but I think you're opening up a whole can of worms regarding people's health records and the safety, how we hold on to those records, how we dispose of them after the 3 years, in a way that, doesn't cause any problems to the people who are involved.
Just quickly, because I think Mr. Johns was first, but
NDP 15 or NDP 16? I just want to get a clarification.
it's NDP 15.
NDP 15. Okay, thank you very much.
I apologize. I was looking at NDP 16.
Okay. I apologize, Mr. Johns. I think someone was debating a different amendment. Did you have anything on 15, Mr. Fergus, or can we go to a vote?
Amendment on 15.
Okay.
Completely.
Shall NDP 15 carry then?
Unanimously?
On division. NDP 16, Mr. Johns.
This, again, it requires the gathering and annual publication of statistics regarding the career and health trajectory of whistleblowers as a direct performance indicator. There is a lack of direct performance indicators by PSIC. Virtually all accounts of federal whistleblower experience in Canada reveals careers ended, health damage, and lives shattered. There's no official data available regarding the career and health trajectory of whistleblowers and no attempt to acquire this. Only the federal government has the information authority and resources to obtain this information, which is inaccessible to researchers and others for reasons of confidentiality, and this is critical to any effective 5-year review of the Act. And again, I'm hoping we can just vote on it.
Mr. Fergus?
I won't repeat myself, sir, but what I pointed out before was my objections to this one.
Thank you.
Hoping that people would understand the importance of people's health records and the safekeeping of that, confidentiality of it, so that doesn't follow them or track them or, unfortunately, get leaked.
Can we move to a vote, colleagues? Okay. Madam Chair?
Thank you, sir. On NDP 16, Mr. Fergus. Mr. Baines.
Against.
Mr. Housefather.
Against.
Mr. Jawari.
Against.
Ms. Thompson.
Against.
Thank you very much. Mr. Barrett. Ms. Block.
Nay.
Ms. Kuzi.
Nay.
Madame Viola.
Oui.
Mr. Johns.
Yes.
8 nays, 2 yeas.
Okay, 16 is defeated. NDP 17, Mr. Johns.
Gathering an annual publication of client satisfaction as a direct performance indicator. There's a lack of direct performance indicators for the Public Sector Integrity Commissioner. Multiple reports by the Auditor General and Judicial Review decisions show that PSIC incompetence, gross mismanagement, failure to provide due process, etc., always disadvantaging the whistleblowers. So in considerations of PSIC's performance, the voice of whistleblowers is completely absent and unavailable, and this amendment would make data available on public servants' feeling of protection and support, which would serve an important direct indicator of PSIC's performance. And the purpose of the PSDPA and C290 are to protect and support whistleblowers. So whether or not public servants feel protected and supported then is obviously absolutely central to whether the PSDPA is functioning as it needs to. So any review of the Act that doesn't consider these metrics is an incomplete review, and if public servants don't feel supported and protected in making disclosures, far fewer of them will report wrongdoing, and wrongdoing will continue to fester unreported, damaging the public interest. So the reporting of this data would also motivate integrity commissioners and their staff to ensure due process for whistleblowers. This would not require additional funds because the evaluation and performance measure matrix for the PSDPA requires measurement of whether employees quote, feel supported and protected when reporting a wrongdoing under the Act. And in fact, the PSIC has promised but never conducted a client satisfaction survey of whistleblowers. So I'm hoping we can just vote on this too.
Mr. Fergus?
In NDP 16, it also applies to NDP 17 in terms of ensuring that there is consent from the whistleblowers to be able to provide that information, that private information. Second thing, again, this also covers a case where, this is where you're dealing with complaints which have gone to the commissioner as opposed to ones that have been resolved internally, or to which the complainant had decided to pursue internally. This will require effectively an annual survey to be conducted by PSIC, and again, we're very concerned about how we might run the risk of releasing people's confidential situations on how of their current status. So for the same reasons that we opposed 16, I think applies to number 17, Mr. Chair.
Yes, Mr. Johns? Great. We can go to a vote, Madam Chair.
Sir. NDP 19, Mr. 17, excuse me. Mr. Fergus.
No.
Thank you, sir. Mr. Baines.
No.
Mr. Housefather.
Contre.
Merci. Mr. Duroy.
No.
Ms. Thompson.
No.
Mr. Barrett. Ms. Block.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Or.
See. Mr. Johns.
Yes.
5 yeas, 5 nays.
Yes.
Okay, and a yay from the chair. So 6 yeas, 5 nays.
NDP 18. Oh, Mr.
Okay, so
Johns.
again,
Page
this-
38.
I'll try to go as fast as I can. No additional funds required. Requires the periodic gathering and publication of indirect performance indicators. There is little to no information available regarding public servants' perceptions of the effectiveness of the whistleblowing system, the frequency of perceived wrongdoing that is supposed to expose and deter, and the effectiveness of corrective actions. This makes it impossible to determine the trends that would tell us whether the legislation is having the intended effects. With this amendment, data would be available showing levels and trends in indirect performance indicators related to public servants' perceptions. These would provide a basis for review and improvement of the legislation and its implementation. They're necessary for the regular reviews of the Act to present a realistic picture of how effective the Act is. This would not require additional funds because the Public Service Employee Survey questions are reviewed every cycle, and there's no obstacle to adding these types of questions to it. In the U.S., the Office of Special Counsel has conducted 3 cycles of this type of survey, demonstrating an improving trend.
Mr. Fergus, then Ms. Kusi.
So I really do disagree with my colleague on this one in his statement that this would have no additional cost. In fact, this will have a significant additional cost. This is providing another survey of public servants, similar to the Public Service Employment survey, which is done every year. I could tell you, Mr. Chair, digging deep on this, we found that each piece, PSES, that is the employment survey, costs well in excess of $1 million a year. The entire budget for PSIC is just over $1 million a year. We'd be virtually, just to run the survey alone, would increase the cost by 100% of the commissioner's office. And this would be in addition to having a new function and responsibility by for the commissioner, who doesn't do this, but this would be something that they would have to make sure that they have new authorization to spend this money to conduct this survey. So, and just to let you know, the Public Service Employment Survey is only done biannually, every 2 years, sir. For the purposes of finding out what we do, where public servants are at, how are they feeling, in the status of their job. Now to have PSIC to double this work, doublement de ce travail, ça va créer un.
If we're doubling this work, then it's going to create additional costs and significant additional cost.
Ms. Kusi?
To make a sub-amendment to the amendment, which I hope might be friendly, and that is eliminating Section D. We have concerns about anonymity in keeping in Part D. So I would be looking to remove Section D, please, Chair.
Brian, can we vote on Ms. Kusi's sub-amendment? Oh, hold on one moment, please. Sorry, we just need to suspend for a moment for our legislative clerks to look at an issue. Are advising me that sub-amendments have to be provided in writing, so we can either rule out of order, or we can suspend for a couple moments, and you can put in writing for us, Ms. Kusi.
Yeah, I
The
mean, I
sub-amendment.
can. I'm happy to put it in writing. There, like just 2 sentences, or what does the extent have to be? And I can loosely
4.
translate it as well. Excuse me, 4 sentences.
Whatever your
Okay, sure.
sub-amendment is.
All right.
You will put it in writing?
Yeah.
We'll suspend for a couple
I'll
moments,
suspend
colleagues.
but I don't want to hold up the process. I will.
Here, I have paper.
I have some right here. Thank you so much.
Sorry, I know we're urgent discussion regarding pens. Ms. Kusi's amendment, of course, if we eliminate D, section C has the word "and" at the end, so we have to change that. So basically, I will read it in. If everyone's fine with it, we'll adjust Ms. Kusi's amendment, that the amendment be amended by adding "and" after paragraph B and removing the following from paragraph C, "and." And then we get into Ms. Kusi's sub-amendment. Mr. Fergus?
Sir?
No problem. We go to a vote then, colleagues, on the sub-amendment. On division. Carry unanimously instead. Now we are back to the actual amendment itself. Mr. Fergus.
So, thank you, Mr. Chair. I do have a difficulty with this because with this, I'd like to thank Ms. Kusi for making the change on removing some of the confidentiality parts of it. But in regards to the to NDP 18 as a whole, as you can see in Section A, it calls for, or at the very beginning, 2.01, the Commissioner must conduct an annual survey to determine, and then it goes on for its now 3 provisions. So that annual survey has to happen. I mentioned that to survey public servants in relation to the way they feel that disclosures are managed under this Act. That means surveying all public servants. That would be equivalent to the analogous to the Public Service Employment Survey, which does cost a considerable amount of money, probably in excess of the entire budget for the Commissioner's office as it stands now. That is a significant expense. And so there you go, Mr. Chair. I think we'd be better off for this amendment to not happen to Bill 290.
Mr. Johns?
On the costs?
Yeah, and whether it would impact, it would require royal assent.
Royal assent, you mean royal recommendation?
Royal recommendation.
Okay, so in terms of
Jeez.
royal, it's okay,
Tired.
it's okay. In terms of royal recommendation, as before, I say that's not of my purview, so I'll leave it to the legislative clerk to say that. But in our view, would create a cost, because if you look at your 2.01, it's the Commissioner must conduct an annual survey. This doesn't say work with the PSES and include questions. So he or she would have to create its own survey that would be applied to all public servants in order to get this information. And therefore, it would require methodology, question design, applying it, and so on. The other thing that I would like to say is that the PSES currently asks a number of questions that are covered by A, B, and C in terms of awareness and the ability. So there could be an opportunity for collaboration to include some of the key questions of the PSEC in the current PSES.
I believe what he's saying. I feel if you were to amend it to include it within the public service survey, that would also be sufficient, which according to his reasoning, that would suffice, because then you're folding that survey into the bigger survey. That would be my suggestion.
Mr. Fergus?
If he's sincere, which I'm sure he is.
I am sincere, and
Yeah.
if I could riff off of Mrs. Kuzi's
Yeah.
suggestion, is that by folding it into the PSES with the appropriate questions and then remove the requirement for it to be an annual survey, then that would really, really work. But if you make it an annual, you're just doubling the cost of the PSES. I'll leave it to you to do so, to making sure that it captures where... do you want me to? May I make a suggestion that you might withdraw it, but then maybe the committee could make it clear in its report that we would expect that the PSES would include questions.
Okay.
That would.
Yeah. Okay, I'll go with that. So I'm going to withdraw.
We'll need UC to withdraw. Sounds like it.
Thank you.
Thank you.
So NDP 18 is withdrawn. So shall clause 33 carry as amended? On division. On division. Mr. Fergus, did you have something for us, or on 33?
That's fine, thank you.
Great. Okay, clause 33.1, it's a new clause. We have NDP 19, which is page 39 of the package. Mr. Johns.
Okay, so this, again, no additional funds required. It requires appointees to the position of Integrity Commissioner to be independent of the bureaucracy and qualified to lead an agency whose primary mandate is investigation. So Integrity Commissioners drawn from the bureaucracy are a serious conflict of interest between that are in the, that are from the bureaucracy are in a serious conflict of interest between the investigative mandate of PSIC and their future career prospects in the public service. 3 successful integrity commissioners, all drawn from the bureaucracy, have demonstrated similar behavior, consistently favoring the rights and interests of bureaucrats over protection of the whistleblower, contrary to the purpose of their position. So this behavior has been reported both by the Auditor General and by judges in judicial review decisions. According to a focus group report commissioned by PSIC in 2022, few public servants trust the agency, and a commissioner must be appointed who does not have a conflict of interest that might deter them from investigating suspected wrongdoing through fear or favor. So a commissioner must be appointed who will be motivated most of all to ensure that whistleblowers are protected as witnesses essential to their investigations. And with this amendment, there'll be that. I'm speaking a little bit ahead. The PSIC will have greater credibility. Public servants will be more likely to trust the commissioner and to come forward with disclosures. There will be greater public confidence in PSIC, and more wrongdoing will come to light and be remedied. So I've kind of spoken on, I guess, 19, 20, and 21 altogether, but I think if we could just vote on 19 first, and then...
Mr. Fergus, then Ms. Kusi.
Mr. Johns, I will speak to 19, 20, and 21. In regards to 19, I do think that it's sort of a little bizarre that you would bring in someone who has no experience with the public service to try to understand what happens in the public service, to better understand where the complainant might be coming from. It just seems that would be it's sort of asking a judge not to be a lawyer first.
Just to 19 first?
I'll stick to 19. So that's
Yeah.
this is
Thanks.
where I'm going with on this one. So I do think that that it just doesn't really add up. I'm not certain where the conflict of interest happens. The person is no longer a public service. Person is no longer holding a job in the public service when they're appointed commissioner. That is their job. They're not double dipping. I'm not certain where this comes from at all.
Ms. Kusi, then Mr. Johns. Amendment 19.
Yes, of course. I was going to ask that we change not employed in the public service to the Public Service of Canada. I think because it's better defined, but I feel, I don't know. Let me think here for a minute. I guess would the government be open to, would they, as I understand it, they're currently objecting it. I guess they would still object it if we put the Public Service of Canada versus the employed in the public sector. So in that case, I guess if all opposition parties vote to support it, then it is not significantly material, but material. So I guess that would be my sub-amendment then. That it's, one moment, let me just
Again,
confer with my
we would
desk.
need sub-amendment would have to be in writing to our legislative clerk.
You know what? I'm going to withdraw the sub-amendment. It doesn't feel material enough to spend time on it at this point. Thank you.
Mr. Johns, then Ms. Vignola.
I'm going to be really quick. We heard many times from the witnesses that their concerns around this. And, you know, it's funny because we write laws, and I know I'm one of the few not lawyers in this table here. You know, they're okay, sorry, there's only a couple lawyers then. But I think you got my point. So.
And we're into lawyer bashing now, I see. Ms. Spignola, then Mr. Fergus.
Très rapidement.
Very quickly. The commissioner that the committee wants to meet with this week is not part of the Canadian Public Service. She's actually a specialist from New York. So the government is actually already applying the amendment that's suggested by the NDP before it's been carried. So I don't see why this amendment would be a problem now. Thank you.
Mr. Fergus.
Question, c'est juste parce que cette candidate.
It's because this candidate is not part of the Canadian Public Service. This doesn't mean that no candidate should ever be a member of the Canadian Public Service. We're neutral on the idea. And the example of the appointment of Ms. Harriet, sorry, I forget her last name, Ithaloe, actually proves that we look for the best candidates, period. And in doing so, we will eliminate the possibility of nominating someone who has had a career in the Canadian Public Service. And then, Mr. Chair, if I can ask a question to our witnesses here today. Is this a conflict of interest? Having this criteria in the amendment. Thank you very much for the question. I will give you a bilingual answer.
The trust. I just want to point out that the officers, those working for the Auditor Generals, those doing internal audits with the government, they are public officials. And I think we all strive as public servants to be impartial and to do the best job possible. So that's one thing. The second thing is that when you read the amendment, it says that at appointment, a person should not be employed in the public service. So let's say that I apply. If I quit government the day before I am appointed, I can still be appointed as the PSIC. So I don't think that this will have an impact at all on given how it's written, because it says that it's the governing council appoint as a person not employed. No one is employed when they because they will have given their notice to the federal government or the provincial government and wherever they work in order to take on that job.
I think Ms. Spignola was... Did you have your hand up, Ms. Spignola? Okay, it was Mr. Housefather, then over to you, Mr. Johns. Although, Mr. Housefather, your hand's down now.
Yeah, Mr. Chair, I was going to ask the question that the legislative or that the witness just clarified. My understanding, and I just want to get it repeated, is that essentially someone who is in the public service can apply for the job. And what this amendment would require then is that the person from the public service, if they were indeed selected, would simply have to resign from the public service immediately prior to their appointment, and they could still be appointed. Is that a correct understanding?
Yes, it is. And that's what happens now in terms of, because you cannot be work for both the government as a federal public service and be an appointee as a GIC.
Mr. Johns?
I'll just wrap up that, again, I've outlined the case around the concerns raised by the Auditor General, judges in the judicial review, the focus group. I'm going to move to a vote, but that this is something we've heard loud and clear, and so I'm hoping that we'll support it.
Madam Clerk.
DP 19, Mr. Fergus. I'm sorry, that was yay? Nay, thank you.
Sorry, nay. Yeah.
Excellent.
I didn't hear you.
I didn't hear you either, so there we go. Mr. Baines.
Nay.
Thank you, sir. Mr. Housefather.
Against.
Thank you, sir. Mr. Jawari. Ms. Thompson. Thank you.
Against.
Mr. Barrett. Ms. Block.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Pour.
Mr. Johns.
Yes.
Result is 5 yeas, 5 nays.
I am going to vote against on this one. Thank you.
Okay, the result is 6 nays, 5 yeas.
We have NDP 20. Mr. Johns.
It's no longer relevant, so I'll withdraw 20 and 21.
We just won't put them forward. We are now on clause 34, and it's G 10.1, which is page 41.1 of our package. It's not standalone that we have to vote on.
Okay, great. Thank you.
G 10.1, I assume, Mr. Fergus?
Mr. Chair, this is a consequential amendment to a vote that we took much earlier in our first meeting, which was carried by the committee. And this is just ensuring that we have the ability to refer this to more than just one person, as a complainant has more than one person to access to pose a complaint to if they have a complaint to make. Yeah.
Okay, we move to vote on division, colleagues. Shall amendment G 10.1 carry on amendment? Or on amendment on division? On division, colleagues?
Unanimous?
Wonderful. Shall clause 34 carry as amended? On division. Now, colleagues, 35 to 40. There's no amendments. Can we have UC to bunch them, or do we wish to address individually? Mr. Fergus?
If the chair would seek it, I only have a couple of. I have one complaint, one clause that I'd like to negate. It would be number 38. I'd be happy to speak to that if appropriate.
We need to discuss 38. Can we have UC to carry 35, 36, and 37, group them together? Yeah. On division, colleagues? Wonderful. Mr. Fergus, on clause 38.
Clause 38 is one which I just think we just have to ask a question. It proposes that the bill seek consent from individuals before disclosing their involvement in an investigation. I can easily understand why the complainant wouldn't mind disclosing, but the person who's being complained about, I doubt they would give their consent. So I'm just not certain of the utility of this amendment, of this provision of the Act.
Un instant. Le commissaire et les personnes...
Just a second. So those acting in their name can bring... The interpreter does not have the text.
Dans le cadre d'une enquête, sur les autres dispositions de la présente loi... Hein. Et la crainte, M. Fergus...
So, Mr. Fergus, what was your concern?
Question. Si on requiert le...
If we require the consentment of each person, I'm struggling to see how this would be in the interest of the person that is alleged to be responsible for reprisal in this complaint. I don't see how they would give their consent to reveal their name.
Thanks, Mr. Fergus. We'll just give Ms. Vignola a few moments.
Monsieur le Président, si c'est pas
Mr. Chair, if it's possible, could I ask our public servants as well to respond? Thank you.
Welcome their input.
OK. Merci pour la.
Okay, thank you for the question. So basically, given that any individual that would be accused, so we would be asking any accused individual for their consent to reveal their name, and the idea is that they wouldn't want to do this. For the rest, it makes sense, but if someone is facing allegations, we struggle to see how this person would like to make their name public.
Ouais. OK. Actuellement, tout.
So right now, everything is confidential until we request someone's consent, and I understand why you're saying that this person would likely say no. The goal here in requiring everyone's consent is to respect these individuals, but also to protect the whistleblower and other public servants. So if we reveal this person's name, on the one hand, it forces this person to no longer commit wrongdoings or reprisal because we know their name. But at the same time, I do understand what you're saying, because the person who is alleged to have committed a wrongdoing may not want their name to be revealed. And so the question I'm asking is, if everyone says yes except for the person concerned, then would it be the same? So you're saying everyone except that individual? Yes. But if we include these names, the person facing allegations will likely never say yes. So I think it's useless to put it here. So I think that we could remove this, and the rest would work fine. Okay?
La partie, s'il vous plaît. Pardon?
Sorry? Your mic. So I was wondering if we could write an amendment on this. Can we remove these words? Do we have to do it in written form right now?
Required in one language in writing for the analysts.
OK. Donc, on
Sorry, one moment.
On retirerait.
So we would remove 44.2.
Okay, thanks. Ms. Vignola, I have some advice from our legislative clerks here. You can move the sub-amendment, but there's issues where it may have flow-through effect for the rest or the bill in its entirety. They're suggesting something like this should come from the law clerk and may not be probably bluntly a good time or the right time to be proposing a sub-amendment. They're not able to weigh in on whether it would be a valid sub-amendment or not, but it's, Ms. Kusi's was a very, very straightforward, simple one. Yours probably is not, and it could have multiple effects through the bill and probably should have gone through drafting clerk. So up to you, but probably not best to move a sub-amendment on this one at this moment, considering time.
Alors,
So we can vote on the clause as it is presented. Or worst case scenario, what may happen is that the accused may refuse to have their name revealed. That's the worst case scenario. And then the report would not contain their name, which is not a disastrous consequence either. So I suggest that we vote on Clause 38 as is.
6 minutes away from our hard stop. Frankly, we could actually just adjourn now and give you time to have it drafted properly, or we can just stand it and come back to 38 at a later time. How about that? We'll come back at a later time. We'll stand it. Yeah, we just need unanimous consent to stand it. Wonderful, colleagues. Thank you very much. We're now on, shall Clause 39 carry? On division? Thank you. Shall Clause 40 carry? We're still on 40. Yeah, Mr. Fergus?
I'm certain our legal legist will agree that we should perhaps...
This is on Clause 40?
This is on Clause 40, and there are consequences to whether or not the debate that we had skipped earlier on G6 in Clause 10 that we were going to get back to. Depending on what we do there, will have consequences on Clause 40. So may I suggest that we move along, skip that as well until we get to that end part.
Mr. Fergus is asking to stand Clause 40 based on the outcome of G6. Do we have unanimous consent to do that? Yeah. Wonderful. Thanks, Mr. Fergus. We will stand Clause 40. We're now on a new clause, 40.1, which is CPC 5. With a bit of luck, we can get through CPC 5 and Lib 11 before we have our end. Ms. Kusi for CPC 5?
Yeah, so this is simply a coordinating amendment to allow for definitions mentioned through our other amendments to be determined through regulations.
Mr. Chair, we agree with that amendment.
CPC 5 carry. On division. Carried. Sorry. Yes, carried. Sorry. Apologize. Lib 11, I understand you are not putting that forward?
No, we are withdrawing. Thank
Wonderful. Clause 41. Shall Clause 41 carry? On division. Wonderful. We're now Clause 42. It's a new clause. We have G11, page 43 of the package. Mr. Fergus?
If I may, Mr. Chair, there are two amendments which are coming before committee, G11 and G12. In G11, we're looking for this to come into effect come into force by a government and council change, and of course, at number G12, we're looking for coming into force 2 years after this receives royal assent. So I don't know if you want to have a debate together or if you want to have it one by one.
Well, G11 is adopted, G12 cannot be moved.
That is correct.
So we can just do on, sorry, just one moment, please. I'm advised you have to decide, Mr. Fergus, whether you wish to proceed with G11 or G12.
Then we'll start with G11. Sir.
G11? Did you wish to address him, Mr. Fergus, or are you done?
Sure.
And
There
we'll
are
go to
a
Ms.
number
Vignola.
of, I'm really done. It speaks for itself. This is a motion that would allow it to come into force by government and council to take into all the elements that are here, and so things which are done, which can be implemented quickly, get implemented quickly. Those which require some working out of whatever budget implications that there are would come into force later.
Thanks, Mr. Fergus. Ms. Vignola?
Très rapidement.
Very quickly. I think that 2 years is very long. I'd prefer 12 months. That would mean royal assent would be probably in June after the third reading is done. But for the decree, I have to be in agreement because this is aligned with the Greek calendar. The order and cancel can be pushed off as long as we want. And I don't want to see that. And so I think we should put royal assent at 12 to 15 months. We can decide upon that, but this will allow the system to adapt and get ready to apply the bill or the act at that point. And then this will give us a clear timeline. And it's at the goodwill or lack of goodwill of whoever makes that decision within the government at that time. So for me, 11, it's definitely a no for me. I'm more open to 12 than 11.
Anyone else? Can we vote, colleagues? Shall G11 carry? Madam Clerk?
On G11?
Recorded vote?
Mr. Fergus.
Oui.
Mr. Baines.
Yes.
Mr. Housefather.
Mr. Chair, can I just ask a precision? This is G11, which is
Mr.
coming into
Fergus has
force.
voted yes.
I know I wasn't asking that. I
Oh,
know how he
sorry.
voted. I wanted to ask. This is G11 coming into force on GIC that Ms. Vignola was against, correct?
That's correct.
Would it not be
But we're
possible to vote
we're
on
voting now, Mr. Housefather.
I
Sorry, you missed
understand.
your opportunity. We're voting now.
Okay. Thank you. I've been against.
Thank you. Mr. Juari.
Support.
Ms. Thompson. Support. Mr. Barrett.
Against.
Ms. Block.
Against. Fine.
Ms. Kuzi.
Against.
Madame Vignola. Mr. Johns. 6 nays, 4 yeas.
G11 is defeated. We're now, we'll try and get to G12 before we have to adjourn a couple moments. Mr. Fergus?
And so this will come into force 2 years after a royal assent.
Ms. McNulloch, do you wish to address?
J'ai parlé précédemment de...
Well, earlier I talked about what I thought. 24 months seems long to me. I could suggest a friendly amendment for 6 months. The current process for adopting a bill this would be about around September for royal assent, and so this would give us the time and the space for the system to get ready to implement this. Do I need to write out the motion? Yes, the amendment rather.
Thinking as we're past our hard stop of 6:15, that perhaps you put in writing, and we will address at our next meeting. Colleagues, before I adjourn, I'm going to seek some resources, see if we can fit in some time tomorrow. I'll advise everyone late tonight or first thing tomorrow morning if we can continue C290. If there's nothing else, we will adjourn and see everyone Wednesday or perhaps tomorrow, but I'll let everyone know first thing in the morning. If you can watch your emails. Thank you very much. Ms. LaRouche, Ms. Stevens, thank you again for your help. Legislative clerks, thank you again. We're adjourned.